You're listening to Heavily Accented Philosophy of Law, a podcast powered by the ALF Project.
Welcome to this new episode of the podcast Heavily Accented Philosophy of Law. Today we have an episode featuring Pedro Moniz Lopes from the University of Lisbon. Pedro, welcome.
Thank you very much. Welcome, Jules. It's wonderful to be here with you and Bojan.
And then we also have me, Julieta Rabanos, as usual, and then Bojan Spaić,
who is still far, far away, hopefully coming next week. Some of these podcasts live. Hi, Pedro. Nice to see you, and welcome to Belgrade. Even if I'm not co-hosting this time, hope you'll have a wonderful time during Belgrade Philosophy of Law Week.
Thank you. Won't be the same without you, but I'll do my best.
Okay, let's start this episode that is going to deal with issues about rules and principles, and then equality, and then also analogy. But then we can start with the same question as usual. Tell us something about you academically, if you want personally, okay, but what was your academic path to the present?
That's a great question, because in Portugal, much like Germany, you're not supposed to do legal theory and legal philosophy exclusively. It's a little bit frowned upon in your early stages. So the idea is that legal theory and legal philosophy is for guys in their 70s, when they have written extensively about constitutional law and other things. So I started out as a teaching assistant in public law, and focusing specifically on constitutional law and administrative law, and then made my way up or sideways to legal philosophy. So that's pretty much how it is. And in Portugal, and this is the bad side of it, is that you basically do everything in the same university. So I'm a graduate, master's, PhD, everything all at once at the University of Lisbon.
We won't let you get away with it. We won't let you get away with it completely. So you have to tell us, what did you do? At least, what did you do right about for your master's and PhD?
Sure.
Exactly.
Okay. So when I graduated, we had to choose. So we have 4 areas. I graduated pre-Bologna, and we have 4 areas of knowledge at the university, which is private law, public law, law and economics, and history of law. So I chose public law, and then I started my master's in public law, but I had a subject of legal theory with a guy you might know called David Duarte, who had just recently made his PhD. It was called public legal theory. So it was a way to, put legal theory, or find a way to include legal theory into public law. And I wrote my master's thesis on the principle of good faith and administrative decisions. Discretion conferring norms and the limiting capacity of the principle of good faith. So basically that was it. My main conclusion, nobody really, academics cared, but I think I was cited twice by the higher courts, which is a very, very low ratio for a public law scholar, but a good badge of honor for a legal philosopher, so I like it. My main conclusion was that the principle of good faith both reduces discretion and grants discretions in some situations. So that was the master's. Then I immediately went into the apply to the PhD right after finishing the master's. I was high on legal theory, so I wanted to do legal theory exclusively. But again, I had some advices from very reasonable people saying, listen, you can do legal theory, you can do a thesis on legal theory, but just include something of dogmatic aspects of law. So I was really excited with the feasibility back then. I was reading a lot, and it was right after I had started writing that book edited by Jordi Ferrer and Giovanni Battista Ratti was published at Oxford. So that was a huge influence on having some sort of thing to wrestle with, because I subscribed and agreed to some things, but I was very critical to others. So that was a good thing for the thesis. And I eventually wrote my PhD on normative defeasibility and administrative norms. So basically, I found a way to write 300 and something pages exclusively on normative defeasibility, and the remainder 700, which is stupid because the University of Lisbon requires you to write a lot of things, was basically applying that theoretical framework to the Portuguese legal system and extracting rules of conflict out of that theoretical framework. So that was it.
And not if it makes you feel better, the University of Belgrade used to do the same thing in my generation. Now they scaled it down quite a bit. So the volume of my work in Serbian until my PhD measures in thousands, basically. So thousands of pages, which is very weird.
Crazy.
And I'm kind of glad that, I'm very glad that these traditions, I don't know in Portugal, but they have changed a bit in Belgrade and in Serbia. What I want to follow up with, you mentioned David Duarte, which is of course a great friend and philosopher of law, and I hope certainly that we'll have him soon on the podcast. So he kind of started, but also with you and with some other members of the younger now not so younger anymore generation started a great thing in Lisbon, which you had now, and it's called Lisbon Legal Theory Group. And kind of, could you reflect a bit on the development of this group in the last 10 years, parallel to your working on your master thesis and on your PhD, because it might be interesting to our listeners?
Yes, we dropped the group. Now we're Lisbon Legal Theory. So it's kind of like Napoleon Bonaparte when he's always only called by Napoleon. So eventually we'll be LLT, and then I don't know, we'll just be one letter.
X.
So yeah, X. Well, so we started in 2015. Just before the IVR in Washington. I had submitted my PhD thesis in 2014, and I had to wait 1.5 years for discussion, which was actually very stupid, but that's the way it goes in Lisbon sometimes. You just wait in line and until they call you. And there was it was basically me and David doing legal theory. I mean, other professors were teaching legal philosophy, but in a very traditional sense, with no international connections. Well, not that I had an international connection back then, because I didn't. David had some. And so he basically said, how about we form a group and we go to this Imperia in Alicante, the Italian, Spanish, French connection on legal theory that started in that little town near Genoa that Jules knows much more about than I do. And we took this road trip. So that was really exciting for not a young kid anymore, but yeah, I was in my very early 30s.
A young scholar.
A young scholar in my very early 30s. So I was super excited to get into that. but before that, we had some informal meetings. We called ourselves the Circle. How original, and how a little bit pretentious. It was not my idea. I always disliked it because we were being.
It was David. You can say.
Yeah, you can.
The covenant.
Yeah, you can. Like I was. Yeah. You can see David saying that. You can see me being a little bit embarrassed and saying, listen, maybe don't aim so high. And you can see David in like 6 months saying, we're the real Circle. We're much better than them. And so that, but let me tell you this. I think, and I mean, all credit to David, who was the driving force behind this project. And it's his way of doing things like crashing through the walls to impose a new set of ideas, and I'm actually the guy that tries to balance that, saying that's a little bit too much, that's a little bit, it's always too much actually, but that was it was that sort of. I would say not necessarily ambition in the sense, but the sense that if everyone's doing that, not everyone, but it's some people are doing it, we have the conditions to do it, and we can start something. So, I mean, I had discussed this with some people, and in political processes, and this is political in a sense, you need someone to, break the wall down and sometimes be idealistic. Then you need someone to come after and say, okay, let's make this stable and work. But I don't think I would, if it weren't for David, like pushing us to the limit on doing things and not stopping, because the amount of work has been incredible since 2015 up to now. I've been trying to rest, and I haven't been managing to, because he keeps on pushing and pushing. This wouldn't happen. This wouldn't have happened. So, but I have come to know that there's someone like him in all the in the aspects of pushing to the limit, in all the I would say interesting fora of legal theory in Europe. So kudos to David. Yeah.
Coincidentally, that IVR in Washington that you connect with the formation of Lisbon Legal Theory Group was also the venue in which we met, discussed for the first time, formed our initial friendship, and we've been following each other, our respective groups, ever since, I think, that IVR. So I wasn't thinking about it, but it's almost since the inception of the respective groups, which is kind of fantastic and nostalgic. And before we start hugging each other and crying, let us, Jules should maybe introduce us to the substantial questions.
Yeah, you cannot hug because you're not here. So that is also...
like virtually hugging.
We can cry.
But that going back to some of the substantial parts of the episode, which is like moving a little away from the logistics of legal research in the sense, and the way in which legal research comes together in the forms of groups. So one idea that was very important and then also very commonplace in, let's say, maybe some types of classical legal philosophy of legal science was that legal systems were composed by only one type of norms, and this type of genuine norms in any case needed to be accounted for in legal science, theory of law or legal philosophy, depends on. But then naturally it came the idea that maybe it was not just one type but different types. But then the last distinction that came, I think that in this let's say, evolution of the way in which we think about norms within legal systems was the division between rules and principles. Can you explain how this came to be?
Yeah, I should say, in connecting this to the formation of the group, the distinction between rules and principles was really our gateway into legal theory and legal philosophy. Back then, David and myself were completely obsessed with this topic. Alexy played a great role in exciting us and then being the target of violent criticism. So it's sometimes I think that I got whatever knowledge I have on general topics such as linguistics and even logic and structure of norms through the topic of rules and principles. So it wasn't like we had general courses on topics such as philosophy of language or whatever, and then we applied it to rules and principles. My way of seeing things was, as I told you, coming from the constitutional law, seeing that these norms behave differently, and I was super excited in trying to find what was something like the Holy Grail. So at a certain point, to address the question directly, I was completely unsatisfied, because I think David was a little bit more Alexian than I am. I was completely unsatisfied with the standard criteria for distinguishing rules and principles. But at the same time, I was sufficiently convinced that, Hart's basic theory of not distinguishing, then he, of course, in the postscript opens up for a distinction. But Eugenio Bullygin's account of legal systems that does not distinguish different structure or behavior of norms was also insufficient. So my idea basically was trying to, having as a point of departure, if I can say, Bullygin's very rigorous and accurate application of logic, but at the same time trying to explain what happens when principles and rules apply. So I then was very influenced by this paper, 1972, Joseph Raz's Legal Principles and the Limits of Law, that I think is incredible and not cited enough. So it was much more enlightening for me than any writing, of course, to his merits, to Alexy's merits as well, but it was much more enlightening to me than any of Alexy's papers on rules and principles. And I got the idea of specified actions and unspecified actions from Raz. And ever since, I really been trying to use that as the main criterion for distinguishing, and also trying to clarify that some of Alexy's ideas are basically generalizations that do not hold true, that all principles collide and whatnot. So I've been trying to use rigorous tools, but at the same time accepting that in general legal practice they do apply in different ways. So
to scale it down a notch and move it back a bit, the Raz's article, as far as I remember, tries to define some ways in which we understand legal principles, or in which we define legal principles. And I would say that one of those ways is still the dominant way in which legal principles are understood in legal science, in the sense of the most general rules of a legal system that are used basically as kind of not even interpretative tools, but interpretative aid when we deal with rules that are not defined, precise, determinate enough. But what has come to happen in the writing of Alexy, in your writing, in the writing of David, and in the writing of the entire Alexian school, is that the concept of principle came to mean a more specific thing. Could you address this specific meaning of principles and the difference between rules and principles within the principles theory?
Yeah, so the basic idea, and to come back to the point where I said that I was, notwithstanding his merits, of course, not convinced with Alexy's theory and not that of Dworkin that came before him, that I think just basically characterize some features of principles, but they weren't trying to put them within a general theory of norms. So my idea was always, okay, so we have a general structure of norms, which is the antecedent, the deontic modalization or the deontic operator, and the consequent. In my view, the antecedent necessarily contains a set of addressees, the hypothetical action, and the occasion. That's a general feature of norms. You have to have addressees, hypothetical actions, and an occasion, even if it's a universal occasion or a generic occasion, whatever you want to call it. And so I started from that general structure of norms to find differences, kind of like in a differential diagnosis. If I have a rule and I include this, how would it behave if I have a principle? And so I would assume that something X was a principle because it's called a principle. I was not assuming that it definitively is a principle, for that was the conclusion that I wanted to reach. But I would assume, okay, let's say that this is a principle because everybody calls it a principle. What happens if I change this or include that, include this occasion and whatnot? So, and that led me, contrary to what I thought, to, and I'm connecting this with a relevant aspect of the theory of principles, to a weak distinction. Contrary to what I was thinking, I was going towards a strong distinction, but then I focused on the specificity of the action that is being governed by the norm. So to the extent specificity is a matter of degree, which is something that seems rather, although debatable and hard to grasp, seems like a good assumption, then the weak distinction between rules and principles as a matter of degree would make sense. But that led me to say that if a weak distinction makes sense, a weak distinction makes sense in every kind of aspect that we're dealing with in legal theory and in life and even in biology. So the concept of weak distinction is a rather tricky one because it can be blurred. So, long story short, I concluded that I could say that, okay, for practical reasons, because it would prove too much a weak distinction, I'm adopting a strong distinction, but not a strong distinction in the sense of Alexy. I'm saying that there's a qualitative difference between rules and principles focused on the genericity of actions, because I can't draw a threshold that divides specific actions from generic actions. And I think it's a very simple, difficult to apply, not simple to apply, but very simple to grasp criterion for distinguishing rules and principles, and explanatory, I think. I think it deploys a very nice explanatory power. But I've been, some people have told me, oh, so you're Alexy and you adopt a strong distinction. No, I adopt a strong distinction just because I also adopt a strong distinction between men and chimpanzees, even though it's a matter of degree. So, but we do call men and chimpanzees, not primates that men, human people, not just a matter of degree between them. So that was my argument for saying I come from the weak distinction, I adopt a strong distinction just for that purpose. And I can elaborate on the criterion if you want.
Yes, we were going to ask about that.
Okay.
But then I want to push before going to specifically genericity, which I think that is the main criterion for you to distinguish between rules and principles. I wanted to push you more a little about this criterion, because traditionally this weak and strong thesis about the distinction between rules and principles are basically divided within quantitative and qualitative criteria, in the sense of, like, as you said, degree or essence, or in this sense. But then when you say that there is a distinction between human and chimpanzee, or man and chimpanzee, in this sense, I think, or what I hear is that you are thinking that there is some level in which you think that the distinction is about degree, but at the same time, a level in which you think that the division is about quality. But we are talking about the same objects. So in this sense, as rule and principles may exist or not, what entities are they? Because I think in this sense, maybe the analogy with something that you can touch, for example, like a monkey or a chimpanzee or a man, may not be too good for like rules and principles. I wanted to push you more on this.
Yeah, that's great question. It takes me to the deeper aspects of it. So I might be a fictionalist, so I don't think they exist, not in the strongest sense. It has to do with maybe I sympathize with error theory and mathematics, but then actually David Plunkett was in Lisbon a year ago, and he was presenting on after mathematics. So what do we do if we're an error theorist? I don't think he is, but he was presenting on that. It was nice to have that subject back, but I think it was basically, well, that's what fictionalists say and have said prior to that, is, okay, we have this mathematical stance. I don't think they exist, so I sympathize with nominalism. Abstract entities do not exist. Not if you're talking about existence in the same way of human people and chimpanzees in the real world. I don't really... It's not that I don't care. I find it extremely interesting to discuss the existence of norms and the hyletic conception and the expressive conception, of course. It's very interesting. But I don't want to divert my attention to those specific metaphysical aspects of the existence of norms. So I found this very easy way to suppose it exists, or let's work on this. When I say the existence of norms, I'm just doing it for a very pragmatic side of it. So, and that allows me to treat non-physical, mind-dependent entities such as rules and principles as if They were existing objects. So that allows me to. I never liked very much the metaphorical way of dealing with legal theory, but I do find extremely interesting that the analogy that I use nowadays is not human people and chimpanzees, is ducks and swans. So ducks, suppose you have, like Bojan would say, the legal system is comprised of ducks. Alexy would say, no, you have ducks and swans, and like swans are completely different. They behave in a different way. They conflict. They're balanced, not necessarily. He's extrapolating, because ducks can also do that, and swans are more liable to do that, but it's not a necessary feature. And I would very humbly say that I come into the discussion and say, listen, you guys, we could say very long, elegant ducks that have really bad temper, or we can just call those very long, elegant ducks with very bad temper swans. And that's useful because it allows us, and actually that connects with my interest in categorization as well. You just use this there's this very interesting paper by Bartosz Broszek, and he says that the distinction is purely didactical or like pedagogical. I don't think it is. It is very useful because it's not just about teaching at the universities, because you can have heuristics there. If you say, listen, this is a principle, you can confirm very easily if you have a set of criteria, and it allows you to quicker and steadier reasoning on that norm. So I would say that, again, I tend to use fictionalism as this bridge that allows me not to be contradictory, I hope.
It is an interesting answer, because one thing that we didn't talk about truthfully was your definition of norm. You already said that, and I think that is something that is underlying in some sense also the way in which these different authors think about the distinction between rules and principles and the possibility naturally of arriving to such a distinction. You mentioned categorization, but we are going to arrive to that. But before, maybe we can talk more about genericity and this criterion that you were thinking, and maybe the elements.
Sure. Just the quick thing on the last question when you said my definition of a norm. So when I started sympathizing, read a little bit about Nelson Goodman and nominalism, and how Platonism and essentialism was flawed. And I read a little bit been trying to read more, but haven't read much, but I read a little bit about the existence of abstract entities, numbers, and classes, and that convinced me to present myself as a non-factualist more than a nominalist. So I don't know, there's no possibility of ever ascertaining whether abstract entities exist. So I cannot assert the truth of the fact that they exist or they do not exist. I'm comfortable with that. I sympathize more with nominalism. So I see this, maybe this makes no sense, but I see a parallel here with agnosticism regarding the existence of God. But so a very skeptic agnosticism. I am in no condition to say that such entity does not exist, but I heavily rely on the non-existence. So non-factualism would place me in that situation. Genericity. So to guide you through very long story short again, I was, starting the PhD with that hype. I got to find the criterion. I got to find something that is really original. And I was mixing things that could make sense, others that could be contradictory. And I read this book by Claudio Luzzati from the University of Milan called Genericità, Principi e Principi, la genericità del diritto. He uses genericity in a different sense. I've been struggling terribly with this because Bulligin talks about generic cases. Raz in the 1972 talks about generic norms in another sense. Luzzati talks about genericity in a different sense as well. So it's very hard to talk about genericity, and I need to clarify, not in that sense, but that's the way it goes. And I read that book, and actually I just wrote a paper for the essays in honor of Claudio Luzzati, who recently retired, and it was very interesting because I had never met him. I had no idea how old he was when I read the book. But he was a huge influence from afar because he led me to some literature on genericity. So basically, I put all those things combined, and my basic intuition was, okay, and I was reading a little bit about logic, the universal quantifier and the existential quantifier, and I was thinking, okay, so we have a rule, smoking is forbidden. That means that every particular instances of smoking are forbidden, whether you smoke a pipe or a cigar or whatever, whether you smoke at night or day or whatever. That's the universal quantifier. But when you have freedom of expression is permitted, it is, and I'm doing this and there's balloons appearing. And I'm saying this in a very non-technical way, so I'm starting with intuitions. When you say freedom of expression is permitted in the Constitution, it's pretty much accepted that not all instantiations of freedom of expression are permitted. And that leads me to what I have now called acknowledged diffusibility as opposed to accidental diffusibility. So that gave me the idea that kind of looks like as if you're saying, by default, and Claudio Luzzati had an expression linking genericità with va tutto bene, meaning I don't really care about the specifics. I'm just saying, Swedish people are tall. Not that each and every one is tall, universal quantifier. I'm just saying Swedish people are tall. So the example that I used, I'm obsessing about animals and zoology. So when you say like mammals don't fly, like suppose Jules, you say, what do you think about mammals? And I say, well, mammals don't fly, and you say no, because I know about bats. Bats are mammals and they do fly. And I will reply, okay, Jules, take it easy. I was not saying that each and every mammal does not fly. That's the universal quantifier. I'm just saying mammals don't fly, and I'm saying this from a very specific, high-level, generic point of view, and that sounded very interesting and very, and that led me to read on generic statements. What does it mean when you say? And then I bought some books about genericity. There's not many books on genericity, but there's a lot of not that many papers. It's a niche, and I like that niche. But it gave me wonderful insights because there's this old generic statement or well-known generic statement that is uttered between the generic members of the generic group, which is the group of people that dedicate themselves to genericity, which is ducks lay eggs. Okay, but only female ducks lay eggs. Only non-sterile female ducks lay eggs. only non-sick, non-sterile ducks lay eggs. And that is way below 0.5. And at the same time, it is truth. Well, depends on the truth conditions, but it appears to be truth when you say something like ducks lay eggs. And that made perfect sense because you can still say, so I'm trying to draw some parallel between descriptive speech and prescriptive speech. It does make sense to say that freedom of expression is permitted, even if someone tells me, listen, Pedro, in the last 10 years, the majority of cases in which, in this particular legal system, people wanted to express themselves, they weren't able to do so. Okay, so but that's a different thing. So what I hear a lot of people saying that rules are less defeasible than principles. You have to be very careful about that, because one thing is the linguistic or logical aspect of principles that make them kind of, it's what I call very, long story short, wise as well, acknowledge the feasibility. But it depends on the real world whether they are frequently defeated or not. I know rules that are much more frequently defeated than certain principles. It doesn't make them principles. So it was also a battle against, for instance, I just remind me of this. I read Aulis Arnio's rule-like principles, principle-like rules, and that was so confusing, even though he had some great ideas, but it was so confusing. They are something, but we'll treat him like this. And a lot of people saying that if they behave in a certain way, then they are principles. Or I'm treating this as a principle. And that was so confusing. And Genericity was really incredibly interesting in providing for a criterion. So promoting is a generic action. Expressing is a generic action. Smoking, treating is a generic action. Smoking, behaving is a generic action. Speaking is a specific action. So you have to put a little bit of philosophy of action and individuation of action, of course, into that. But it gives you a very, very sound criterion. And Luzzati also influenced me about the inclusive and exclusive disjunction, and I came to this conclusion that basically the difference relies or is on the action, the hypothetical action. That's the only difference. And if the action is generic, it is because it is an inclusive disjunction of specific actions. Why inclusive? Because a principle is just one norm, not a set of disjunct norms, and that was it. The problem then, and the interesting part then, and I'm just finishing this part very quickly now, is that when you get a criterion, you get new problems. So it gave me new stuff to study and to inquire, because if I accept the generic conception of principles, then it necessarily follows that Alexy is wrong, because principles do not collide. They cannot conflict, because the action is not a universal quantifier, and you need to have a universal quantifier to get a conflict. And this was something that Guastini said, that you need to extract rules. But actually, I read that in Guastini after concluding this, and I think, okay, so he was on to this, but then Guastini said you need to concretize principles, and I was not satisfied with concretizing it. Now I'm interested in knowing, how do you extract, what kind of intellectual operation is this, extracting rules from principles? And that's really, really interesting, because I think, to finish this part, and it has to do with maybe brain activity as well. If I say freedom of expression, you cannot grasp the meaning of this if you don't think about a specific action. You cannot just use generic actions. So I don't think you can have. I had this discussion with Diego De Vecchi. He said you should go back to the concept of action in von Wright, von Fricht, or you want to call it, because maybe a generic action is not an action for that purpose, and that's currently the state of affairs of my research. Super long.
Thanks, Pedro.
Answer.
Let me. No, it was actually a great response and a very interesting one for me. I started thinking about these issues by following your work and having these discussions mostly in conferences, the work that you did and that David did. Well, let me try to wrap it up, and in your reply after I follow up with a question, you can also address my kind of a recapitulation. So basically, our default understanding of principles was mostly regarded as this understanding that differentiates rules and principles based on a level of generality, in the sense understood by most lawyers that the principles are the most general rules or norms of a legal system, and that is what we referred to when we were discussing the positions and the various meanings attributed to principles by Raz. Then in the principles theory that was actually started by Dworkin, we had this idea, or at least this strong idea, that we can only identify this difference when we have situations of collisions between norms or situations of collisions between rules and principles, in the sense that the collisions between rules are decided according to traditional canons of deciding which rule will be applied and which rule will not, like posterior rules derogue prior rules or remove them out of the way. But what was interesting to me in your work was that you were trying to find a difference, and I'm not sure about this, but I think that you were focusing kind of on, at first at least, on the semantic of rules or and principles, or how are they formulated, what's that in their formulation that warrants you to call one formulation a rule formulation, the other formulation a principle formulation, and you move toward this criteria of genericity. And it followed with I think also a difference kind of in methodology. You were more open to think about these issues not only in a conceptual manner from the perspective of logic, but also in a manner that involves more of cognitive sciences, let's say neurosciences, some hard sciences, as we would say. But and you can comment, of course, on if I did a good job of rendering your position in these couple of sentences, but I wanted to pass to this part of the conversation, or to the next part of your work that you've been doing for some years now, I think, that's related to classification, and more precisely is actually related to equality. How does equality factor in these discussions and classification, these discussions regarding genericity and principles?
Actually, I was always been interested about equality and discrimination law, and also from an extra legal political stance. Of course, it was also always a subject of interest to me, and I found out that it does have very interesting connections to the issue of that we've been discussing, genericity and rules and principles. So just to I think you did an excellent job in synthesizing. And it's really accurate, the fact that I've been progressively open to other explanations. I don't really care now anymore if I'm grounding the difference on very rigid syntactical criterion. I called this paper of mine, 2017, Genericity as a syntactical criterion. I now use, whatever powerful explanatory response I can, and I'm progressively. This is perhaps going further into naturalism, whatever explains this. So I remember this Quine sentence. If telepathy works and ghosts exist, then fine. Physicians just need to go back to their drawing boards and try to explain that. So I'm open to a lot of explanations. I don't exclude them just for the single fact. And there's this one thing that I want to connect to the question that you asked about classification, categorization, is that principles seem to explain. So there's this theory about genericity. You can use induction, which is a nuisance because you need to go instance to instance confirming things and saying I can get a principle out of this because by default, I'm now using a non-legal rule. Metal expands with heat. So I can have this, I can see this metal expanding with heat, then this other instance, and I conduct another experience, and I induct. But there's this new wave, not new, but another wave. I think it was Carlson, the author that coined it, which is that generic statements somehow correspond to the underlying causal forces of the world, which is a different thing. So it allows you to say, okay, so ducks lay eggs, that somehow corresponds to the underlying, very inexplicable, for the time being, forces of the world, the real world, even though induction might not apply because non-sick, non-sterile female ducks lay eggs. And that might be below 50%. And I try to apply that to, and this is where categorization kicks in. I try to apply that to legal system. And again, having completely different criteria, Guastini was very inspiring here when he has that little paper, Los Principios en el Derecho Positivo en Distinguiendo, where he says something like, principles have a huge capacity to explain legal systems. So I'm not quoting directly, but something like, if you know the principles of a legal system or micro-legal system, you basically know a lot about that legal system because rules will just be extracted or the results of conflicts or something like that. So they have a huge capacity to explain, not to explain because they don't explain, but to be the sort of the DNA of the legal system. And I thought, okay, so that somehow corresponds to the causal forces of the real world. So principles are like, there's this interesting parallel there that you cannot blindly apply, of course, but gives you the idea that you're onto something, like the Sein-Sollen distinction, causal forces in design. Are there causal forces in design? Not in the same sense, of course, because cannot be applied the same way, but maybe there's something there that you can work on. And that led me to categorization, because again, rules and principles is a sort of categorization. And I read this 1977, this is being recorded, I might be mistaken, so please check the date, paper by a cognitive psychologist / philosopher called Eleanor Roche, heavily inspired by Wittgenstein and by the great Amos Tversky, a cognitive psychologist / philosopher that wrote on similarity. and she was one of the main proponents of prototypical theory, theory of prototypes, sorry. And she has this principle called principles of categorization. Very small paper, but very enlightening. And that paper, she basically says, okay, so categories are not necessary by definition. So she talks about, it starts with something about some emperor that had a set of animals that names of which were not initiated by this letter. So she was making weird categorizations. Instead of saying this animal, that animal, she was making weird categorizations. But at the same time, she was saying, listen, okay, it's not necessary, but it's not like as if anything goes. There are principles. And remember, she's a evolutionary psychologist, so she's a cognitive scientist. She's talking about psychological principles that govern the categorization. And she talks about two psychological principles, which are I actually don't specifically remember what she talks about, what the names she gives them, but one is mirroring the structure of the world. So I come up with a category because I want to anticipate something about that. So bats fly because that's a feature of them, and others do not fly. So I'm building a category based on that distinction. And the other is cognitive economy. I cannot go around making super fine-grained, specific distinctions. Otherwise, everyone will lose their minds, and the brains are not equipped to compute those many distinctions. And that paper was also hugely inspiring because starting out as a constitutional lawyer, I thought, okay, this is suitability first and necessity after. So you use categories as a means to an end, which is to anticipate the way things behave. And at the same time, you use the principle of necessity because, cognitive economy, because you cannot go further than what is necessary within a cost-benefit analysis to use certain categories. And I thought, oh my God, this is super interesting for discrimination. All the issues that you have, for instance, there's this discussion in Portugal. Well, not a discussion. We actually have a moderately conservative government that included the category of people that menstruate instead of men or women because of transgenders. So, and what was the explanation for that? They didn't provide for a theoretical explanation, but it was basically mirroring the structure of the world, predicting certain aspects, cognitive economy, and trying to get what I've been trying to coin. I don't know if it was Eugenio Bulligan that told me this when I briefly met him, is that you need to come up with certain things, coin certain terms, and get them to, place them around. So I'm trying to coin, hope nobody did this before, but if they did, oh well, optimal inclusivity. So that would be, it's a chimera, doesn't exist. But the idea, borrowing from Schauer's over-inclusiveness and under-inclusiveness, there are ways in which you can have sort of a Pareto optimality of inclusivity. So people that menstruate would be higher in the criteria of optimal inclusiveness than men and women for a certain specific task at hand. So you see how this connects with analogy. Just basically same thing with certain differences. Because when you're analogizing or using equality or categorizing, you always need to take into account what you want to do with that. Cognitive scientists say that analogies are different depending upon the goal that you have with the analogy. If you want to come up with a certain legal regime for people that menstruate, you use people that menstruate, you don't use men or women. But if you are talking about other aspects, people that menstruate might not be the best category to devise. So, I think that would be my very long answer to this.
Just to jump in.
Yeah.
So we are talking about equality, and then we are talking about analogy. Mm-hmm. Can you draw some parallels, distinctions between these two things, or maybe between sameness in a wide sense and analogy?
So, I progressively think that we are... I've been blurring the distinctions. Basically, analogy is the application of equality, and equality is analogizing.
So basically, we move from strong distinctions to the blurred line of the distinction between equality
all
and
of
analogy.
All of a sudden, I can't even see you well. You're all hazy.
No, it's. I mean, it's. This is on, right?
Yes.
Yeah. Because
unfortunately it's still on.
Yeah, the ear thing fell. Of course, you go into a law faculty, you know that analogy is usually talked about as a gap filler. So analogy is connected with gaps, filling the gaps. There are certain goals for analogy, but you have analogy, disanalogy, equality, difference, similarity, dissimilarity, sameness, all those concepts. My basic idea about this is the following. So identity, we can forget about identity because identity is A is identical to B, means that A and B are the same thing, so there's no A and B. It's A and A or B and B. You just call it different things. So if you think about the Phrygian reference, whether it's Venus or the evening star or the morning star, same reference. So they're the same. The example that I use is Jim Morrison and the Lizard King. The Lizard King is the same thing as Jim Morrison. They called him the Lizard King. Unless you include a distinction, which is sort of the persona. If there's a different personality in Jim Morrison when he's the Lizard King, then it might not be the same thing. So it depends on the set of properties. But won't matter for the issue of equality. So we can disregard identity. Similarity is something that can be measured, and I refer our listeners, I wanted to use this expression, to Amos Tversky's work on similarity, which was incredible, even in anticipating many aspects of artificial intelligence. So similarity is described and measured. Equality is not. And I also refer our listeners to a great paper by Paolo Comanducci on equality. Equality is not described, not measured. Equality is instituted. So when you're declaring equality is not described, it's declared, so different speech act there. First you measure something, some properties, then you highlight the relevance of those properties, then you institute equality. So basically what you're doing is setting an analogy. If you read papers on analogy and the steps of analogy, abduction, induction, deduction, you're just doing the same thing. So I'm abducting this as the relevant property of this and that. I will put all the members of the set within the category, and I will deduct,
Deduction?
Yeah,
To deduct, yes.
To deduct, yeah. Well, I had a brain freeze. That member is this member that particular is a member of the set. So again, lawyers do it. It's hard. It's weird from a guy that intends to call himself an analytical legal theorist, an analytical philosopher, to say that lawyers are over analytical there, because sometimes all the things about analogy being this specific thing and equality being a constitutional principle, it amounts to the same thing. It's the basic structure, is the same reasoning there. And the reasoning there is categorize. When you are analogizing, you're extending the category. When you are disanalogizing or differentiating, you're restricting categories, creating different categories. What is interesting there is, unless you have this, school of thought that professors can do whatever they want and judges, and I think they do whatever they want. I don't think they can do whatever they want, or they ought not to. But unless you think that they ought to do whatever they want, you need to have certain objective, steady criteria for differentiating and analogizing. And this has to do with separation of powers and with basically power to analogize, which I think is actually the most powerful power that lawyers have, is to analogize and differentiate. It's like they're reshuffling the whole legal system. The legal system was designed, it's in place, you need to apply it, and then comes a professor saying, makes no sense. And that's why I want to use analogy as an explanation to the application of the principle of equality. That's to lower the power of people that basically use the essence of things. They call Aristotle on the stand, and a lot of philosophers saying, this cannot be because these things are different. No, that's an elliptical statement. It makes no sense to say that two things are different. You need to say regarding which relevant property and why that property was highlighted as relevant, and that's analogy. That's analogy. But most judges, and I will stop here, most judges, I won't say most, but a lot of judges get away with philosophical parlance, sometimes mumbo-jumbo, in convincing an audience that two things are essentially different. But there is no such thing as essentially different. And that's my nominalist thing. I like Nelson Goodman's sentence, there are no horses. I think he says something about horses. There are no horses. Yeah.
You heard it here first, on a podcast at least, so there are no horses.
We are not going to edit that out.
All of your answers prompt me to ask you a million questions, and the only reason why I'm not interrupting you constantly and doing that is Jules.
Yes.
Yeah, they're basically the only reason, and some time constraints, because we're in the middle of, or at least you're in the middle of the Belgrade Philosophy of Law Week that encompasses a lot of administrative and academic stuff. So I wanted to force you a bit to do a kind of a wrap up, and I'll start like this. I don't think that I wrote much about rules and principles in English, but I wrote a paper in Serbian and got into some weeds and details about the Alexian position. What fascinated me at the time, might be 2018, about the position was actually this thing in which Alexy, inspired by Dworkin, took a thing that we already do with principles in certain cases, for example, when these principles collide, and used it to kind of formalize it, to make something out of it that is workable, in the sense that he managed to kind of, or at least I think so, to codify a way of thinking, or to formalize a way of thinking that was inherent in the legal profession. And we know this at least since the 19th century, or the end of the 19th century, in administrative law, in on the territories of today's Germany, and so on and so on. So I basically, what I see in this work and what I see in this discussion is a very, very interesting continuation of this analysis. And I am interested, and you mentioned that a couple of times, whether, how would you frame it, all these discussions as a whole, and how would you frame it as a whole from the perspective of a municipal legal system, as Hart would say, or a legal practitioner from an internal point of view, in the sense that there seems to be, even if we tend in philosophy of law to have this technical, that seems highly abstract level of discussion, there seems to be a lot of points in which these issues are of high or extreme practical relevance.
Okay, that's a challenge to wrap it up. Let me see if I can. Okay, so I went through, like, it's like you have the different stages of grief. I had not stages of grief, but I had different stages of Alexy, of dealing with Alexy. So I was super excited first. I was highly frustrated afterwards, and I was being picky, and I was not using the Donald Davidson's principle of charity, so I was being a prick. I never wrote anything like that, being a prick, I think, but in between papers, I was in discussions, I was being extremely critical of Alexy, pointing out contradictions, specifically saying he's formulating universal laws as if principles necessarily behave like this, and they do not, it's contingent. And then I thought, maybe influenced by this movement, like Schauer's take on coercion as not a necessary feature of law, but basically being there most of the time, and I like, you don't necessarily need to talk about necessary and sufficient properties all the time. And I was like, okay, so Alexy tries to explain something, and he says this many times, even his weight formula that also is very criticized, but extremely useful in some senses to explain how the German Constitutional Court works. Fine. So I think he was, and I'm progressively interested in this. He is also someone that works on fundamental constitutional rights and constitutional law, and he managed to get a communication, a connection with legal practitioners. So I have a lot of friends who are not legal philosophers, and they read Alexy and they say, that's helpful. Because I know when I want to, claim something before a court, and I want to say that this principle conflicts, like access to administrative information. We have a law that basically says something like, like privacy of the corporations or commercial secrecy needs to be balanced against access to administrative documents. And those legal practitioners, they don't really care about if I tell them, no, the balancing is contingent because it depends upon another norm existing in the legal system, and even rules can be because of Alchuron and Bulligin's example of the red light in front of the military barracks, they won't care about that. They will love Alexy because he managed to set a connection, simplify. Like I see Alexy, I don't want to be misunderstood. I don't want to say that he's not deep, not at all. But I see it. It's very interesting. You can only go into deconstruction afterwards when you have a sense. So imagine, I don't know if it happened to you, like you're trying to teach your first year student or something, you will omit some kind of complexity, otherwise you will mess with his head. So when you want to explain rules and principles, the participants will say, okay, principles collide and they are required to balance, because that's what happens 99.9% of the time. Fine. Whoever comes next and is picky and saying, well, but that's 99% of the time, okay. I think they should be a little bit charitable. Well, Alexy needs to be a little bit cautious also with the universal truths that he sometimes puts forward, but at the same time, you need to be a little bit charitable about that. What I think is the great question to be asked now, but this is just an opinion, is how do you extract rules from principles? How do you, what is the requirements to extracting rules from principles? Does it require a collision? And so I would say that that's the state of the art now. And I think that will not necessarily be solved only with logical and linguistic analysis.
Well, one way is creating something akin to alpha chain for predicting the structure of proteins, making an artificial intelligence that just endlessly derives rules from principles. Mm-hmm. But it is an issue that we are going to discuss. I hope on another occasion with you when we do a different topic. This is, I think, and it is slowly time to wrap it up. We covered the most important topics regarding rules, principles, equality, categorization, and even analogy. What do you think, Jules?
I would say so, and I think that it has been wrapped nicely. The only thing that I wanted to add is that we were wrong. It is not deduct, it is deduced.
Ah, okay.
Heavily accented philosophy for you.
Perfect.
Like
okay.
live.
Just for our listeners, I was trying to say deduce, but I was muted, so I was just shouting away needlessly here.
I was clueless. So it's nice that Jules fact checked, as should happen in a podcast. Okay, so can I just say a final thing about categorization?
Absolutely.
If you can manage. If you can manage it, 1 minute.
1 minute.
Yes.
Okay, it's like.
Or if you can
I just want to restate
another
that.
episode.
I just want to restate that there are no horses.
There are no horses.
There are no horses, and
this will be the title of this episode, Jules.
Yeah.
There are no horses.
No horses exist.
Yeah.
Featuring Pedro Moniz Lopes.
And equality is a relation that is instituted, does not pre-exist in the real world. So we should be very careful about instituting those relations and not relying on those, very unexplained equalities that are supposed to exist in a Platonic world, or that the ancient philosophers told us to. And in 10 seconds, I always remember this passage by Russell in the History of Western Philosophy, claiming that, don't rely too much on Aristotle because he was divorced twice. And he said, not because of that, but he said that women had less teeth than men for some reason, he deduced that, and he had 2 wives, and he never bothered to asking permission to count the number of teeth. So it would be much nicer to categorize based on counting number of teeth, which actually are the same, men and women, instead of relying on this weird presupposition that men have more teeth than women. And I think that that's what sometimes courts are doing. They're relying on that instead of just counting the teeth. That's what I wanted to wrap up with.
Pedro, thank you very much for participating in this episode. Do you want to comment on something?
Definitely not. Definitely not. Pedro used all the bizarre examples and analogies that are allowed within the episode. Usually I use at least 90% of them. Now I have fallen to 10% of bizarreness. Which is also absolutely fantastic. Thank you so much for the great conversation.
Thank you very much for participating, and we hope that we can have another episode with you.
Thank you.